On the record. Friday, December 18 of the year 2020, for the Honorable Jesús-Arriaga Pedrosa, in this court, open court, under Title 28, Section 626, Subchapter Golf, lowercase, for the Honorable Adelina Pedrosa, Federal Postal Judge, sui juris, presiding in this court of record. Under martial law, Rule 203, jurisdiction over the offense. Today, we're going to be introducing a testimony from the Supreme Court for the United States, Justice Clarence Thomas, who we will have the honor to introduce with the speech regarding the language, where he states that it has to be explained on a language that the people understand. As you know, this case has always been argued about the jurisdiction, about the language, about all these abnormalities that these pseudo judges, especially one Cindy M. Mercer from the 13th Judicial District Court on Valencia County, New Mexico, and pseudo judge James Lawrence Sanchez, also on the same court. We have gone over there several times. We have submitted documents. The documents have been kidnapped, have been destroyed, have been concealed. And we have Cindy M. Mercer on the record, on video, striking the criminal complaint, striking the documents of the criminal complaint. And this is case law. Cindy, if you want to do that, you're destroying the system. The whole case will free every criminal out there, because if criminals can do that, and this is the case law that you are making, based upon that, this case law, all the criminals will be able to say, well, I'm striking this. I'm striking the documents. And now, before too long, we're going to start with this because we have some other video to play to you, and we have a testimony from a retired judge. So you're going to hear it from a retired judge, which is going to bring it into the record. And then he's going to be well regarded because he is a retired judge. And nobody has challenged. And he's going to be talking to you about maritime jurisdiction. So pay close attention. First, we're going to go and start with this little video. And then we will take it from there, because it's going to be a lot of fun. And also, we're going to read some documents that were filed on this case. And today, we will be working on case Delta 1314. Dash Charlie Bravo dash 2019 00392. So we're gonna introduce you to this short video now. It's not too long, but it's quite interesting. If you don't believe this guy here, Clarence Thomas from the Supreme Court of for the Supreme Court for the United States, And then you need to go over there and argue with him, because this is forensic evidence. Hey, he's telling you right here. So it is our honor for the Honorable J. Jesús-Arriaga, Federal Postal Judge, who is juries appointed Special Master in Common Law by the Superior Court and a judicial officer of this court, this Superior Court, and presenting this for the Honorable colon Adelina-Arriaga, colon Pedrosa, Federal Postal Judge, sui juris, and one of the people presiding in the Superior Court and in the court, in the Supreme Court for the United States.
Why do we make it complicated? Why do we make it inaccessible? I had a buddy who was a quadriplegic. He was one of my best friends. And this is in the days back in the 70s before you had all these flushed curbs and curb cuts. So every time we got to like a curb, it was like the Great Wall of China. And we would have to, if we weren't there to lift him over, lift him downstairs and things, it was inaccessible to him. And to some extent, that's what we do to law. We start talking about negative pregnants and we use double entendres and throwing a little Latin and a little this. Why don't we talk in English? You know, that farmer in rural Alabama has a right to know what his Constitution says. And so what I do is, one of the things I say, and I said even when you were clerking, is that genius is not putting a $20, a 10-cent idea in a $20 sentence. Genius is putting a $20 idea in a 10-cent sentence. It is to make it accessible as possible to average people. So when I used to go back home, think about it. I came from a world of illiteracy or near illiteracy. And when you went back home, you could not talk down to people. That's what they would say to you. They wouldn't use the word condescend. That wasn't in their vocabulary. You're talking down to me. In other words, you're putting me down. But you had to explain things to them without treating them like they're lesser human beings. So it's what we used to say in the vernacular back in the 60s, you had to break it down. In other words, you had to speak without losing meaning, without losing content. You had to explain it in a language that they understood. And I think one of the things that we try to do in the opinions is to explain things to people. I think we owe it to people. In order to do that, we have to know it, as we do in the classes. Look at the eyes on the students when we're done. When they figure out that they know more about Lochner now than they did before, simply because we've read all the briefs and articles about it, etc., and we know the story behind it. And all of a sudden they can claim it. They understand it. It makes sense. Or if you look, when I wrote separately in the McDonnell opinion, what I was trying to do is, after all this talk of substantive due process, just simply explain to people, we don't know where does it come from? Where does it come from? It's not in the Constitution. But, so you go back and you say, here's what's there. Now, you don't have to agree, but Privilege or Immunities Clause is actually there. Here's what they actually debated. Now, you can disagree with that, but you can see the coherence. You can see, you can go to Dred Scott, and you can see that it was, like Tawny is saying, blacks can't be citizens. Well, that's remedied in the 14th Amendment. And then it says you can't deny them privilege or immunities of citizenship. So it all makes sense once you go through the history. And I think that's what I tried to do in the opinions. It's not so much to give you some legal theory, but to give you the progress of this provision. And then to show you where it's connected to some of the other concerns they had about blacks in the South being able to defend themselves.
Justice, I wish we could stay all afternoon, but I've gotten the
Well, they're leaving, but you and I can stay.
I've gotten the signal that the time is up, but thank you for your remarks.
Well, thank you all for spending this afternoon with us. Sorry to take so much of your time, but and maybe we didn't cover everything that you probably wanted us to, but we're going to be talking later on about the Dormant Commerce Clause for those who are interested. So thank you all very, very much.
Any questions? I take that as a no. Because if you had a question in this regard, you will be showing the world that you are incompetent, that you don't know, that you don't understand, because you don't know, you don't understand, you don't know what you're doing. You don't know what you're doing, and if you're doing this willingly, because you knew or you should have known, it is forensic evidence of malicious prosecution. You don't have an excuse. You went to college. You went to the university, and so did Clarence Thomas. However, we are having here a little bit of misunderstanding with the language. Now that we have that clear up, you claim to speak English, you claim to read English, and then we read the language for the case, which we requested, for the Honorable Adelina Arriaga Pedrosa requested the language, which was never honored. As a way of starting here, we're gonna have a document that we received from that building, from the supermarket court, because it is a supermarket court. The document says, if this hearing requires more or less time than the court has designed, comma, or if this hearing conflicts with the prior setting, comma, please contact us immediately, as continuances may not be granted on late notice, period. The district court complies with the Americans with Disabilities Act, period. Counsel or pro se persons may notify the clerk of the court of the nature of the disability at least 5 days prior any hearing, so appropriate accommodations might be made. Please contact us if an interpreter will be needed. In this case, for the Honorable Adelina Arriaga Pedrosa, wrote and requested the language in which this process, or this bogus process, had to be continued. And then again, we started playing something in Spanish here in one of our videos. For those of you who don't speak Spanish, and now you know how it feels. We also played a brief recording from the air control tower talking with pilots of several airlines. And when it comes to language, you are at a loss. Everybody is at a loss. But now, Clarence Thomas, on the Supreme Court of Justice for the United States, tells you that you have to explain it in a way that the people will understand. The second question here is why are you dealing with people? You don't supposed to deal with people. People wrote the Constitution, and they will not allow to be prosecuted under some doormat commercial clause. As you've heard it, he's going to be talking about this doormat commercial clause. And then we're going to talk in detail if those apply to people. or by what authority or under what authority. But first, we have something for you, and it is our pleasure to introduce this video for your enlightenment. Take your notes, rewind the video, scratch your head, understand it, read it, look for it, because it doesn't get any better than this. This comes directly from a retired judge. And if you wish to question this, well, you're going to have to question him. But this is real law. So none of you will escape. All of you are the experts. You have superior knowledge of the law. You practice law. You sit on the bench. You hear law. You're supposed to do this. You're supposed to do that. But none of you is doing what you're supposed to do. And this is forensic evidence. So now in front of the Chief Justice for the Supreme Court, for the Supreme Court for the United States, we're going to play this video, and he's also watching it. And we are playing this video also on front of, for the corporate United States Congress Oversight Committee. And believe me, there will be no way they can disagree. No way they can disagree, because maritime jurisdiction is maritime. So you cannot bring any maritime law into the territory. And if you don't believe it, well, and then let's hear it from him directly. And now we're gonna go on. Adjust this for your pleasure.
The Sovereign Citizen by Judge Dale, retired. Thursday, April 11, 2013. Our federal government has instructed our federal, state, and local police agencies that everyone who purports to be a sovereign should be treated as a terrorist. They've also brainwashed the American public into believing that being a sovereign is anti-American and unpatriotic. Perhaps this is the pot calling the kettle black. What is sovereignty? It is the inherent right and prerogative of a civilized people to rule itself and to dictate all the forms and conditions of the institutions it sets up to carry out this rule. Once again, I took the time to do some research on this sovereignty. I've been researching it for a long time. When you go back and look at a lot of old citations, it is very clear that the people are sovereign. I found a Georgetown law review that was written by a law professor. His name is Randy E. Barnett. I had made a video on this. I actually took the time to actually make a video like in a movie type form from this. This is something that everybody should read. It goes back to what I was saying. These law professors are questioning a lot of the things that we say. And you can see right here in the introduction where it says right here, constitutional law professors know two things that their students often do not. John Marshall was not the first Chief Justice of the United States, and Marbury versus Madison was not the first great constitutional case decided by the Supreme Court. That honor goes to Chisholm versus Georgia, decided some 10 years earlier when John Jay was Chief Justice. Students may be unaware of these facts because most basic courses in constitutional law begin with Marbury, which, along with Chief Justice Marshall's opinion in McCullough versus Maryland and Gibbons versus Ogden, are the earliest cases that are emphasized. The opinions in Chisholm are never read. At most, the case is mentioned in passing to explain the origin of the 11th Amendment, which reversed its holding. In Chisholm, the Supreme Court, by a vote of 4-1, rejected Georgia's assertion of sovereign immunity as a defense against a suit in federal court for breach of contract brought against it by a citizen of another state. The fundamental nature of the issue presented by the case was aptly characterized by Justice Wilson. This is a case of uncommon magnitude. One of the parties to it is a state, certainly respectable, claiming to be sovereign. The question to be determined is whether this state, so respectable and whose claims soar so high, is amendable to the jurisdiction of the Supreme Court of the United States. This question, important in itself, will depend on others, more important still, and may perhaps be ultimately resolved into one, no less radical than this: do the people of the United States form a nation? And it goes on, it says, in Chisholm, the justices of the Supreme Court rejected Georgia's claim to be sovereign. They concluded instead that, to the extent the term sovereignty is even appropriately applied to the newly adopted Constitution, sovereignty rested with the people rather than with state governments. So right here, you can see very clearly in this case, Chisholm versus Georgia, it was very clear at the onset that everybody understood that the people were sovereign. Now, they have coined this new phrase called sovereign citizen to try to make people look like idiots. I've read case law and everything where this is very clear, that the people are sovereign. This case that came afterward, this is where you start, where they talk about conspiracy theories and things like that. But it was in Marbury versus Madison and McCullough versus Maryland, Gibbons versus Ogden, where it started to change. They started to get this notion, but the confusion comes in because you got to understand what United States of America means and United States, which I'm going to show you later in this video in some of the debates that was on the congressional floor, that it is very clear that the United States is a corporation. It's going to be without question. So you can throw this in these people's face and show them. Next time, try to make jokes and make videos on the internet and so forth, trying to throw around this word sovereign citizen, which is an oxymoron. How a sovereign go? There's no sovereign citizen. And they always spell it with a small c. If you look before the 14th Amendment, citizen was written with a capital C, and after the 14th Amendment, is written with a small c. The difference between a proper noun and a common noun. And this was because the 14th Amendment allowed corporations to be citizens. So check that out and read this. It's in the description. The link to it is in the description. I would highly recommend that you read this Virginia Law Review. Ironically, the U.S. Supreme Court agrees with those people who claim to be sovereign citizens of the American Republic. Bond versus United States, Volume 529, United States Reporter, page 334, the year 2000. The Supreme Court held that the American people are in fact sovereign and not the states or the government. The court went on to define that local, state, and federal law enforcement officers were committing unlawful actions against the sovereign people by the enforcement of the laws and are personally liable for their actions. Bond versus United States, Volume 529, U.S. Reporter, page 334, 2000. Supreme Court, cited by 761 litigants in other cases. Bond versus United States, Volume 131, Supreme Court Reporter, page 2355, the year 2011. Supreme Court, cited by 306. Bond versus United States, Volume 1, Federal Supplement, 3rd Series, page 631, year 1993. Court of Appeals, 7th, cited by 66. What are the implications of this 2000 U.S. Supreme Court ruling? Number 1, the delegates to the First Federal Convention prohibited the use of corporations by all governments representing the American Republic. Therefore, all of these corporate governments and their corporate laws are a usurpation of the organic Constitution of the United States of America. All state governments are now subcorporations of the federal government, making all courts and all law enforcement personnel corporate federal agencies or employees. See James Madison Journal on the Federal Convention, Volume 2, page 722. I took the time to investigate the records of the Federal Convention of 1787, Volume 2, and it was very, very interesting. I recommend everyone read it. I provided a link down in the description to this particular document. It was essentially the debates on the congressional floor when the Constitution was aborting at its inception, of what exactly would go into the Constitution, the debates over the different clauses of the Constitution, and so forth. And I found some really interesting things. I'm still researching it, but I found something that should put to rest anyone who just does not believe that the United States is a corporation. If you just still don't think that the United States is a corporation, here on page 263, we find the United States shall be forever considered as one body corporate and politic in law, and entitled to all the rights, privileges, and immunities which to bodies corporate do or ought to appertain. And I went and got a 4th edition Black's Law Dictionary and looked up the definition of the word body corporate. And here you can see very clearly that it says a corporation, public or private. It is a corporation, public or private, a body corporate. And there's a lot of discussions in here of what the rights are about the United States. There's definitely a distinction all through here of United States and states. There's discussions about treason, what will be treason against the United States. If somebody's treason, it's going to be treason against the state or the United States. These people understood what United States mean. It is very clear in these discussions that they understood that the state and the United States were two separate things. They were two separate entities. Not United States of America. That's a totally different thing. It is United States, and then there is the states, and then there's United States of America, which involves all 50 states, the continental 50 states acting together in concert. So this notion that the United States is not a corporation, if you look into these documents that he's talking about, it's very clear. It's very clear. And pull up your state code on your PC and search the code for the words District of Columbia and federal government. You'll receive about 1,000 references linking your state to the federal government. Number 2, the state and federal government is a corporation, and therefore the Congress, state legislatures, city councils, municipalities, and all state and federal courts are corporate entities posing as constitutional branches of government.
Okay, Shirley, we're looking at this. It's addressed to John Andes.
Oh, don't do that. Oh.
What's important do we notice here?
Okay, first of all, we're talking about the Courthouse Corporation. If you notice, Farrell happens to be a judge. Right here, we're talking about the Courthouse Corporation. The same thing you'll see, that it is a private corporation.
Courthouse is a private
A
corporation.
private corporation.
This is dated 1985.
Right, but it's been going on since 1984. So it is a private corporation, and this is where they float bonds, building courthouses without the approval of the citizens.
These are all the different courthouses and the amount of money. There was no citizen approval for all these.
Right, and it makes it owned by the judges and not the people. I'm going to show you why. As I said before, this is the Courthouse Corporation. And here's the bonds that they've been floating, right here. And this is one of the bonds that they floated. But I would...
The obligation of the county to pay base rental payments does not constitute...
In other words, what they do, they build these courthouses and then they pay rent on the same courthouse that they just built. And this is showing the payment schedule on this courthouse. And here you...
Whoa! We're talking millions and millions of dollars a year in rental payments.
And rental payments. Wait a minute. And you see, Antonovich here, he is appointing Pharaoh, which we saw back here earlier.
Wait,
That was created in 1984, and they use this corporation to float bonds without voter approval. Anything that's private, they don't have to notify the public, but when it's public, so this is how they get around. They create these private corporations.
Number 3, corporations are privately owned businesses, meaning that the corporate United States belongs to one or more private individuals, which is always governed by a board of directors. The corporate United States is privately owned by a group of European royal and elite individuals tied to the Federal Reserve System, and the letters of incorporation are recorded in the Vatican. The President of the United States is actually the CEO of the United States, and the Congress and all other are corporate employees. Everything they do is in the interest of the corporate owners. I can't access those documents because of national security. Number 4, in order to promulgate and enforce criminal laws to govern the sovereign public, government must be sovereign too, which is an accepted rule of law derived from the ancient law of kings. Corporations are not and can never be sovereign. They are not real. They are a fiction and only exist on paper. Number 5, therefore, all laws created by these government corporations or private corporate regulations called public law, statutes, codes, and ordinances to conceal their true nature. Do the judge and your lawyer know about this? You bet they do. Number 6, since these government bodies are not sovereign, they cannot promulgate or enforce criminal laws. They can only create and enforce civil laws, which are duty-bound to comply with the law of contracts. The law of contracts requires signed written agreements and complete transparency. Did you ever agree to be arrested and tried under any of their corporate statutes? For that matter, did you ever agree to contract with them by agreeing to be sued for violating their corporate regulations? Citations and complaints are contracts, but they lack transparency because you were never told what might happen to you if you agreed to contract, and that you had a right to refuse the accommodation. Number 7, do any of America's courts have jurisdiction over a sovereign? Yes, but only by your consent to be judged by the court. Can they compel, summon, or subpoena you to appear or participate in their process? No, they can't compel you, and yes, they can ask, but you can reject the accommodation in writing, and nothing can be done about it because you have refused to give the court jurisdiction over you. Number 8, enforcement of these corporate statutes by local, state, and federal law enforcement officers are unlawful actions being committed against the sovereign public, and these officers can be held personally liable for their actions. Bank versus United States, Volume 529, U.S. Reporter, page 334, year 2000. Number 9, there being no constitutional criminal laws or transparency in the American justice system, everyone arrested, convicted, and sentenced to prison under these civil laws are imprisoned by consent, and therein, all American jails are actually debtors' prisons. Number 10, most of the county and state prisons and all of the federal prisons are privately owned corporate businesses for profit, which kick back to the sentencing judges. The Bureau of Prisons Privatization Management Branch provides general oversight for these institutions. So if you're convicted in these courts, you can expect to serve some jail time. Now you know why America has such high prison populations. Number 11, can the state government and courts take custody of your children? Only with your consent. Otherwise, their agents and officers can be held personally liable for their actions. Orphans are a different matter and can become wards of the court until emancipated. Corporate governments are a usurpation of the organic American Constitution, and this corporatist onslaught in America has since its creation been an anti-sovereign and terrorist regime, and are in fact the real terrorists and traitors to the American Republic. Blessings, Judge Dale, retired.
Any questions? Again, I take that as a no, because if you say, yes, I have a question, that's clear evidence, forensic evidence of your incompetence, because you don't know, you don't understand, you don't comprehend, you are not trained to hold the position that you're currently holding as a judge, pseudo judge. Because you don't comply, or you are not in compliance, of Title 4 U.S. Code Section 101, 1 Stat 23, page 1, Section 1, you don't have an oath that satisfies the Article 6 of the Constitution, and you are in violation of 6 CFR 37.3. At this point, I have repeat these numbers for so many times that you should have gone already and look for what they are, because you're supposed to go look for it. You're supposed to go, you're supposed to know it. In fact, by the time that you go look for it, you're an idiot. You're supposed to know this by heart. You're sitting in front of an auditor. Auditor at law. Auditor on black law. For the Honorable column J hyphen Jesús-Arriaga column Abonce. You don't deal with the people. For the Honorable Adelina Arriaga Pedrosa is one of the people. And a federal postal judge, sui juris, presiding in this superior court under martial law. Rule 203, jurisdiction over the offense. And for the honorable members of the Congress Oversight Committee agree that for those who are not licensed or licensed to practice and in acting as judges, who they can hear law, and at the end they cannot even hear anything, they're deaf. You heard it from Clarence Thomas, and Clarence Thomas is being there, or it was there, or is still there, if he is there, or if he's been there, or if he's a corporation. You heard it from him. It has to be in English. And this is not English. What you are sending is not English. This document comes from the state of New Mexico, Valencia County, 13th Judicial District Court, from Wells Fargo Bank N.A. What does Bank N.A. mean? What does that mean? Or in what language is this document written? It doesn't have any specifications of any language, therefore is written on an unspecified language in violation of Title 18, Section 1001. And you know it, and you should know it, and you know it, and you're doing it intentionally. What is this document in regard anyway? Notice of setting. No means no. So wherever you start with a no, just here, no, right there, no, it's a negative. Therefore, the rest of the document is a negative. You cannot start a positive with a negative, can you? Or since when, by what rule, code, or statute? You can do that. Oh yeah, you can go and do a negative, and then for the rest of it, the whole thing is a negative. If this hearing requires more or less time that the court has designed, the court designs time. Since when time has been designed? The last time I checked, time has been standard for the past 20,000 million years. So since when the court can design a time, you know? And one thing is that design is a design. D-E-S means no. So not signed. Design is not signed. And this violates the very rule that Judge Clarence Thomas has told you. You can't do that. Eso vamos a decir por un momento que yo digo, chole, pinche chango chilango, ya bájale, culero, ¿qué chingados traes? Did you make up for it? Mortis Detis ni las Pataratis movies? Answer, yes or no. So the bottom line here is when you're confronted with a question and you don't it's in a foreign language, you're out of laws. Were you able to answer my last two questions here? No. None of you. None of you. It's a shame that somebody has to dedicate time to this kind of documents that are sent to you by the high, costly, and expensive research of a special master and an auditor. Somebody goes and send you a claim, a bogus claim in a bogus name, in a bogus language, and then they have men with guns that come over to you, and they come in on unmarked vehicles, and they come over here doing all this. It is organized crime. Let's pretend for 1 minute that you are corporate, that you know how to stay within the corporate boundaries. Well, you do it to corporations, not to people. Not to people. In this document is the second read of error. By the time you get a read of error, you are at a loss. You are ashamed. I mean, you know, somebody has to come and point you something that you made an error. You know, by the time you receive the first read of error, you're blown, you're out. You're totally crazy. You don't know what you're doing. So for the Honorable Adelina Arriaga Pedrosa, sent you a document for the Honorable column Adelina Arriaga column Pedrosa, period. One of the people. So if you knew about law, it will be kind of like a shame for you that another lawyer comes and tells you, hey, that is not like that. But if one of the people comes to tell you, hey, that is not like that, you better don't continue. I mean, this is the book Everything is documented. Everything is here, and it is a shame that somebody has to bring it to you. And it says, one of the people, P.O. Box 2441, Los Lunas, New Mexico territory. You are not in the territory. You have no law on the territory. You don't operate in no territory. You are a corporation. Corporations are to their domain, and their domain shall be the federal government or the government itself. When you're a governor or a government or corporation, you're not supposed to go govern any other than yourself. You can't govern people. Corporations are not people. Corporate law specifically says it's corporate law. Get it on your mind. Put it in here. Corporate law is for corporations. Repeat with me. Corporate law is for corporations. And put it in your mind. Weld it in your mind. If your mother is not a corporation and some corporate cop comes over abusing her or hitting her over the head with a stick, would you agree? Would you agree? You see it every day on television, you get in the wrong picture. It happens. Yes, it happens. But it doesn't mean that because it happens, it's correct, truthful, and lawful. By the time you're doing that, and I'll tell you, man, this document here explains in detail, and Cindy M. Mercer, you received this document. For the Honorable, column, Adelina, Arriaga, column, Pedrosa, one of the people, P.O. Box 2441, Los Lunas, New Mexico territory, XXXXX 99-98, federal, postal, judge, and through her appointed special master in common law executor, forensic level investigations team director, auditor in code of banking procedure, and one of the people, for the Honorable, column, J, period, column, Jesús, Arriaga, column, Avonce, period. Case number Delta dash 1314-cv dash 2019-00392 regarding the lower court case. Files claim in this court of record against each of the trespassers, wrongdoers, correspondence names listed on attachment 1 et al. And Curtis Espinosa, agent for the Sheriff Department of Valencia County, State of New Mexico et al. So for the sheriff, too, for the Honorable Adelina Arriaga Pedrosa, Federal Postal Judge or juris presiding the Superior Court of Record, presents this objection. Second rate of error, quiet coram nobis residence regarding the unlawful fraudulent filings documents by Philip Romero, clerk of the court, on 10/02/2019, 40 pages, fraudulently presented by Mark A. Reckner and Thomas M. Sellers, attorneys for Wells Fargo Bank, and filed by Philip Romero, clerk in the court without leave of the Superior Court of Record. And the 40 pages contain no specifications of the language. There you go. On capital letters, you received it. Hey, we have no specifications of the language. Did you get the specifications of the language when I say mortis detis ni las pataratis movies? Did you get the specifications of the language when I say mortis detis ni las pataratis movies? Did you get the specifications of the language when I say mortis detis ni las pataratis movies? Did you get the specifications of the language when I say mortis detis ni las pataratis movies? Did you get the specifications of the language when I say mortis detis ni las pataratis movies? Did you get the specifications of the language when I say mortis detis ni las pataratis movies? Did you get the specifications of the language when I say mortis detis ni las pataratis movies? Did you get the specifications of the language when I say mortis detis ni las pataratis movies? Did you get the specifications of the language when I say mortis detis ni las pataratis movies? Did you get the specifications of the language when I say mortis detis ni las pataratis movies? Did you get the specifications of the language when I say mortis detis ni las pataratis movies? Did you get the specifications of the language when I say mortis detis ni las pataratis movies? Did you get the specifications of the language when I say mortis detis ni las pataratis movies? Do you know that the sentence? Did you understand the sentence at all? Mortis, letis, nipas, pataratis, movies. O chale, pinche chango chilango, ya bájale, güey. It's the language. And you heard Judge Clarence Thomas that there has to be in a language that the people will understand. "40 pages contain no specifications of the language and were filed without jurisdiction, and in violation of Title 18 U.S. Code Section 242, deprivation of rights under color of law." You had received a document. On where you were told that if you continue on that path, you shall be in violation of Title 18, Section 241, 242. It's clear that you didn't regard. You say, hey, this is what I do for a living. I mean, I don't know how to do it any other way. Because you really don't. Or when is the last time that you deal with one of the people and then one of the people sent you this kind of documentation? Come on. Violation of Title 18 U.S. Code Section 242, deprivation of rights under color of law. Violation of Title 18 U.S. Code Section 241, conspiracy against rights. Violation of Title 15 Section U.S. Code Section 1692, false and misleading representations or statements. You're a liar. You're lying. You don't know what you're saying. You're talking. If I went over, say, to your house saying that you, mom, or one of your relatives or dear loved ones or part of your family are doing some crime that they haven't done, then I'm liable for this false statement, and you are bringing false statements. And the worst part here is that you know it. You're a corporate lawyer. You were not told you're corporate, but from now on you go over there. You do the best you can to stay away from those from people. But they threw you in a world of corporations. Well, you should know the standards. Can a butcher come and operate in your mom's heart? No. I mean, hey, a knife is a knife. A hog is a hog. A heart is a heart. But here's one thing. Your mother is not a hog. Now you see it. Now you see it, right? Violation of Title 18 U.S. Code Section 1001, fictitious conveyance of language which resulted in the discrimination and the disability of the disability for the Honorable Adelina, Adelina Arriaga, Pedrosa, to read, comprehend, babble, a confused noise made by a number of voices. Remember Mortis, Detis, ni las Pataratis movies? Confused noise made by a number of voices. Ya chole, pinche chango chilango, ya bájale, güey. That's exactly what it is. Confused noise made by a number of voices. The Honorable Adelina Arriaga Pedrosa is denied equal protection and due process. Because you cannot bring a process in a foreign language. Come on. Who told you can do that? I'm going to bring you a process in Nahuatl. You claim to be very good on scripta continua. Well, Nahuatl is scripta continua. So you will be right at home. Right at home. Violation of Title 18 U.S. Code Section 1342, fictitious name. Where did you get this name? Where did you get this name? Can I call you a name that is not your name? Can I say, well, that's very low and disrespectful. Only vulgars do that. And hookers change their names, and thieves change their names, and they live in the same world. They start bringing their names with a middle initial. That's concealing identity. Willful discrimination. You know you're not supposed to do this, right? But you continue. You continue. You continue because now you are like you don't know any better, so you keep on singing the same song. Have you ever gone to this one place on Disneyland? It's a Small World. This is all they say throughout the entire house, and in your courtroom, they all sing the same song. So you come over here with a different tune. They don't know. They don't know from another song. They don't know from another process. They don't know from another thing. But here they're doing this willfully, and they are in violation, and they know it. This is the worst part: violation of federal rules of civil procedure 12B1, lack of jurisdiction subject matter. You didn't get that? Violation of Federal Rule Code Procedure 11B, frivolous filings, because that's what it is, frivolous filings. Is it a sworn statement? Is it a verified claim? No. This is nonsense. This is bringing false and misleading statements into the court, into a corporation that do not exist. And we wrote exactly onto that effect. We wrote for the Honorable Adelina Arriaga Pedrosa, wrote in this one part, in this one document, we have a truth writ of declaration, and we're going to get to this one in a minute. What I'm looking for is the rogatory. And on the rogatory, in any part of the world, this letter of rogatory should be enough to stop any process, whatever process it is, criminal, civil, commercial, whatever you want to call it. Book number 4, 4 pages, rogatory, case number 1314, Charlie Bravo, dash 2019-00392, regarding lower court case for the Honorable Cindy M. Mercer. Edition. The use of a fictitious plaintiff makes this action a fiction. Don't you agree? Or you didn't understand that part? Edition. The use of a fictitious plaintiff makes this action a fiction and affords no power to this lower court for any action, where no justiciable issues are presented to the lower court through pleadings. Ligon versus Williams 264-111 period alpha papa period 3 lowercase delta 701 comma 637 November Echo capital letters 633 First District 1994. That's the law. That's the law. And this was decided on the Supreme Court for the United States. The same place where Clarence Thomas is sitting down. Do you think he agreed that after we pointed to you this nonsense and you continue, do you think Clarence Thomas agreed that you did the right thing? And did you stop when you were asked for the language? At this point, I just feel terrible for you, because it shows you don't know what you're doing. As it stands, the order herein hereby, the sovereign secure party, notary, witness, postmaster diplomat, notary witness, sovereign secure party. Which one of those terms was so hard for you to understand? Then we go and write the name. Column, Adelina, hyphen, Arriaga, column, Pedrosa. And we have a seal in there that reads UCC 1-308, comma, 103 and 109. Reservation of rights under the under the Uniform Commercial Code. I'm gonna die telling you this, because this is what you need to learn. But you know, it's no need to learn anymore, because in jail you cannot use this. So you're going to jail now. You're gonna go to jail, and now you're gonna be practicing law in there, or saying, hey, I need to get out. Vacation order of this matter. Title 17 U.S. Code section for the failure of this false fraud claim change is with the vacation order of this false fraud case, charge, indictment by the lack of authorization for the relief, column civil hyphen claim 12B6 is one of the most common. 12B6. It's like when you go to the doctor and they give you a medicine like Tylenol. Everybody don't have to be a doctor to know what Tylenol is. And you are a judge sitting on the bench, acting like, hey, I know how to hear law. The minute you heard 12B6, you should have run. With the non-compliance is with the issue of a bench warrant for your arrest. It doesn't get more specific than that. Because now, we are saying, for the Honorable Adelina Arriaga Pedrosa, is saying, hey, if you don't stop, you're giving me all this jurisdiction to put you away for life. But now there is something that you say, well, I'm still gonna continue. And it has a notary witness knowledge. Any document that comes through you with the Great Seal of New Mexico, it shall be respected. I mean, it's coming through you by the Great Seal of the State of New Mexico and by the commission of the Honorable Michelle Vasquez, Notary Public of the State of New Mexico, and her commission expires on 11/10 of the year 20. Witness claimant, colon, Adelina, hyphen, Arriaga, Pedrosa. The Honorable Adelina Arriaga Pedrosa, Federal Postal Judge, sui juris, presiding in the Superior Court of Record. I declare under the laws of the United States of America that the foregoing is true and correct, executed on this 30th day of October of 2019. By column, Adelina, hyphen, Arriaga, column, Pedrosa, Federal Postal Judge, sui juris, presiding in the Superior Court of Record. And it has a notarial certification. None of your documents are certified. None of them. None of your documents are certified, and none of your documents are verified. What kind of claim is this? I mean, we asked for the verified claim. You never brought it to federal court. The case was dismissed in federal court based upon the fact, under the grounds that this was not the real parties, not the real names. It is on the criminal complaint. Go look for it. It's in there. The decision of John Ritters in the superior and in the corporate United States District Court for the corporate district of corporate New Mexico. This is exactly what they wrote. Violation of Title 42, USC 1986. Neglect. You're neglecting. Violation of Title 42, 1985. 2. Obstruction of justice. Hey, this is not justice, is it? Do you think the Congress Oversight Committee is going to say, oh yeah, you were doing justice? Violation of Title 42, 1985. 3. Deprivation of rights. You were told she had her rights. You should have stopped right there. Hey, I got my rights, and my rights are protected. You know, I'm reserving the right to protect my protected rights. And you continue. Violation of AUSC 5, due process. Violation of 42, violation of Title 42, 1985. 3, deprivation of rights. Violation of AUSC 14, equal protection due process. Violation of Title 18, CH 79, 16, 21, perjury of oath. Violation of Title 18, U.S. Code, constructive treason. Violation of Title 18, U.S. Code 241, conspiracy color law. Violation of Title 42, 1983, note 349, conspiracy. Violation of Title 42, 1983, Chapter 21, personal injury. Violation of Federal Rules of Civil Procedure 12B5, insufficient service. Insufficient service. All services are insufficient. They all come in a bogus name, in a legal fiction, in a made-up name, in a fictitious legal entity, fabricated with fractions from the name, full given name, for the Honorable column Adelina hyphen Arriaga column Pedrosa. Totally different name. Now the fact that you go and take this name and then you take two fractions, you go and make a name and then you file a claim against this name, you know you're fried, you're done, you're exposed. Identity theft. Insufficient service. Violation of Title 28, Chapter 85, 1359, collusion. All of you are colluded. All of you. You are working in concert. This is the way you do it. That's why you're an organization. You're organized crime. Pathetic. Willful criminal trespassing by Curtis Espinosa. Now this pig was told not to trespass. Then he left. We have a video. But and then we came back and he had gone trespass and put his document in it when he was told not to do it. That's willful criminal trespassing by Curtis Espinosa. He was told that if he trespassed, $50 million in lawful money minted by the United States Treasury. You know, he says, oh, 50 million, no problem. I'll just go and trespass, put it in there. I'm doing my job, you know. Violation of, we already said this one here, violation of AUSC 5, due process, violation of U.S. Code Section 2071, concealment. And we filed a book. And Philip Romero, what a shame. What a pity. What a sorry story. What are you going to tell your kids when they grow up? This is what I did. I concealed this book so this one lady will be run over by the train. You don't do that. Concealment of the first book filed on July 12, 2019. Missing. Kidnapped by Philip Romero. But here's the interesting part, mister. Here's the interesting part. That at the beginning of this one document, is told exactly in plain English to you, in plain English, second grade English. The Superior Court of Record notice to the clerk to file on demand under Title 28 U.S. Code Section 1361 via U.S. certified mail and to the attention of Philip Romero, Deputy Clerk. 1. Comes now the Superior Court to demand that the clerk not perform any tribunal functions and that the clerk refer to the documents to the lower court for tribunal determination regarding the filing of said objection. All documents withheld from confirmation will be held proof of willful misconduct and official repression from Philip Romero. What did they tell you? Oh, if he brings any documents in his defense, you strike him and throw him to the side? Or like you told me, I will put him on the garbage can? Sorry. You know, it's a shame. And you don't do that. This is people's lives at stake here. This is somebody, a human life, a human being. Would you like for your mother? I don't know how she is. Would you like for your mother to be railroaded in that fashion, Mr. Philip Romero? If you have a mother. But if you don't have a mother, would you like for your wife to be railroaded on that fashion? If you tell me yes, you deserve the electric chair, which you are getting, by the way. You are getting the electric chair. You're being sentenced to life in prison. And if you run away, well, I don't think you can run because with all that weight on you, it will be difficult to run. But if you decide to run, you'll be turning your sentence into death by electrocution on the electric chair. And this is real. This is real. You know, you believe that you were the invincible. They told you right here. Official repression, it will be held proof on willful misconduct and official repression from Philip Romero, clerk of the 13th Judicial District Court of Valencia, New Mexico, The Superior Court requires the clerk to cite all rules to support the clerk's quasi-judicial opinion. The Superior Court hereby places in judicial notice to the clerk of judicial, Philip Romero, that withholding to fulfill your obligations as a public servant and kidnapping any documents is with the fee of $50,000 on lawful money minted by the United States Treasury Department. So if you kidnap this book, boom. But if they told you and you still kidnap the book, oh, now you're showing some bellicism against the lady. You know, you're not supposed to do that against any ladies. Your mother was a lady, correct? Or she is. It is order on the exact date next to Philip Romero's signature in the certified return receipt request or the green card. And you received it. We presented on this just past video. Okay. And this is the request for the subrogation. Subrogation. Second, the rules are clear that the clerk must not refuse to file a paper solely because it is not in the form prescribed by these rules or by a local rule or practice. Federal Rule of Civil Procedure 5, Delta, lowercase, for the Fifth Circuit has held that the clerk does not possess the power to reject a pleading for lack of conformity with form requirements, and a pleading is considered filed when placed in the possession of the clerk of the court. It's considered filed. Once I place it in your possession, it's considered filed in the possession of the clerk of the court when it was electronically filed and the clerk was without authority to refuse to accept the complaint in the miscellaneous page 12. Proceedings. In fact, even if the complaint has been erroneously delivered to the United States trustee or the United States District Court, the court will have discretion in the interest of justice to deem it to have been filed with the Houston Bankruptcy Court as the date of its misdelivery. Federal Rule Banker P5005C Charlie, lowercase, in regard the Heritage Organization Bank. November, Delta, text, period, comma, 2011. And then we cite another law over here. The actions of the court clerk's office require traveling. It is difficult enough to practice law without having the clerk office as an adversary. Rojas versus Costford, 1998. '67 CAL period APP 4TH 774, 777 Rojas, whether Boyd's motion has legal merit is a determination to be made by a judge, not the clerk's office. Wow. You didn't read this, Philip Romero? You didn't read it, or you read it and you wouldn't know, or you were so hungry that you could not read straight. It's obvious you couldn't even make up anything out of this. But you did. One thing you didn't realize is that you are in violation. I declare under the laws. If a document is presented to the clerk office for file in a form that complies with the rules, court clerk's office has ministerial duty to file it. And this is pursuant Carlson versus Department of Fish Game. Even if the document slips open, page 3 contains defects, or the clerk office shall not notify the parties that the effect should correct. See Rojas Supra 67. And by unilateral refusing to file Boyd's motion, the clerk office presented to the court from applying this precedent and on any other relevant law to Boyd's particular circumstances. The clerk office actions violated Boyd's rights under both the federal and state law. And then you wrote me a letter. That says that I needed to comply with the rules of court. Wait a minute. By what authority? Hey, you're being told right here. We didn't put this document in there to make you feel any slimmer or any more intelligent. And this was executed on the 9th day of August of 2019 by the Honorable Column Adelina Arriaga of the Pedrosa family. Complaint and equitable beneficial title holder. Again, under the Great Seal, certified mail to all of it. An introduction on this document. The Honorable Adelina Arriaga Pedrosa is one of the people. Again, XXXXX. Any questions? On New Mexico territory where she's dwelling at 1989 Maestres Drive, Lodena, New Mexico, on the territory. He doesn't live under a zip code. Where do you see a zip code? How can you force a zip code onto someone? By what rule? By what authority? Hey, you know it. Per video evidence, an unidentified individual who drove an unmarked black vehicle SUV type appeared asking if Adelina Arriaga lived at the aforementioned dwelling, keeping location the Honorable J. Jesus Arriaga Abonce asked the unidentified individual if capital letters were used on the papers. Held on the unidentified individual's hand, he confirmed, quote, yes, unquote. Arriaga replied that the person did not live at the dwelling, or the Honorable J. Jesus Arriaga Abonce asked the individual to leave the property. The unidentified individual claimed not to be in Arriaga's property and acknowledged jurisdiction to the street. To the street only. Arriaga proceeded to inform him the boundaries of private property and to acknowledge the no trespassing sign posted on the dwelling and warned him not to trespass or he could be liable for criminal trespassing and a fine on the amount of $5 million will apply. The unidentified individual stated, "You look like you are over the age of 18. I'll just leave them with you." Arriaga asked, "How do you know my date of birth?" and warned him he was familiar with violation of Title 15, Section 1692E. He replied, "No, why don't you tell me?" Arriaga answered, "I'm not on the habit to educate anyone," and refused the fraudulent note, while the unidentified individual covered the perimeter of the fraudulent note with masking tape. And exclaimed, I will just wait for Adelina." J. Jesus Arriaga asked him to leave once more, and he left on a black SUV type unmarked vehicle shortly after J. Jesús-Arriaga left the dwelling, only to come back to a posted fraudulent note posted on the front side of the garage door. Clear proof of criminal trespassing pursuant the statements of the registry on 06-19-2019. Adelina Arriaga refused to accept the service. The Honorable Adelina Arriaga Pedrosa was never addressed by the trespasser, unidentified individual who happens to be Curtis Espinosa. The trespasser Curtis Espinosa activated Title 15 U.S. Code Section 1692E and committed criminal trespassing, and the $5 million fine in lawful money minted by the Treasury Department of the United States of America is now effective and applicable. Formal charges are pressed by the Honorable Adelina Arriaga Pedrosa against Curtis Espinosa and the Sheriff's Department of Valencia County are now effective on July 12, 2019. The Honorable Adelina Arriaga Pedrosa filed special appearance sui juris via United States certified mail return receipt request. Item number 70183090000028324814 successfully delivered to Philip Romero pursuant the green card signature on Philip Romero Exhibit 727D herein attached for reference. Pursuant the fraudulent certificate as to the state of the record filed on October 2 of 2019, or 10/2/2019, at 9:52 a.m., Afian Curtis Espinosa recanted on the penalty of perjury to have had delivered a copy of summons, complaint, and exhibits to the Honorable Adelina Arriaga Pedrosa at 1989 Maestas Drive, Los Lunas, New Mexico 87031, which is felony perjury and count 2 violation of Title 15 U.S. Code Section 1692E, activated by Philip Romero and Curtis Espinosa. 3. Philip Romero also received book page 57, 1 of 1, notice to all parties listed on attachment 1. Herein attached for reference to withdraw or be liable for $50,000 per day filed on August 13, 2019 at 4:02 p.m. and effective beginning on August 22 of 2019, book page 62. And as for the October 25th of 2019, no objection has been presented 65 days later. At $50,000 per day, the liability ascends to $3,250,000. $3,250,000 in lawful money minted by the United States of America, minted by the Treasury of the United States of America, from each trespasser wrongdoer named and listed on attachment 1, and I will continue to accrue until all matters are settled in the Superior Court of Record. Subrogation book. Pages 1 through 16 were filed on July 12, 2019, and as of October 25th of 2019, no correspondence has been received. It's never challenged. Item number 5, book page 19 of booklet file on 7/12/2019 as a special appearance sui juris affidavit of truth notarized with certificate by the Secretary of State and the State of New Mexico has been totally ignored by James Lawrence Sanchez and has been neglected to assist the Honorable Adelina Arriaga Pedrosa. Yeah, he neglected. He says, so I don't know what to do on this one. Because we have a case prior with you and you know who we are. And you wouldn't want to deal with us anymore. That's why you passed it on to this other lady, to this India Mercer. Sad. James Lawrence Sanchez and has been elected to assist for the Honorable Adelina Arriaga Pedrosa under common law jurisdiction. Item 6, book page 20 to 24, filed on 7/12/2019 to all named trespasser wrongdoings correspondents were appraised of the lawful notification with motion to show cause, and as of October 25, 2019, no objection has been presented by anyone of the listed on attachment 1. Item 7, book page 24, filed in July 12, 2019, for the language of the case is very specific in regard to the Honorable Adelina Arriaga Pedrosa's disability to speak, write, or read Bible. You continue. Oh, she don't understand the language? Well, better yet, because we're going to continue. You continue. This should be enough pursuant the Supreme Court Judge, Supreme Court for the United States Judge Clarence Thomas. You heard it from the guy. Can you go over there and tell him no? Book page 24, filed on July 12, 2019, for the language of the case is very specific in regard to the Honorable Adelina Arriaga Pedrosa's disability to speak, write, or read Bible, and 40 pages written in adverb, verb, and Bible have totally disabled and willfully discriminated the Honorable Adelina Arriaga Pedrosa. Bible, so I send it to you in a language that you don't even have an idea, and the Supreme Court agrees that commercial speech is it's an artificial language. Proof different. Real language for artificial corporations. You will never win. Never. Never in a million years. Item 8. Book page 26 and 27 have been audited and marked as the People Exhibits 1A, 2 of 19, and 3 of 19, herein attached for reference in regard to the fictitious unspecified language. Its forensic evidence, page 28 to 24, are yet to be audited by Wells Fargo and its pseudo-agents who are in violation of Rule 601 and 602 of the Federal Rules of Evidence. No first-hand knowledge. You ever heard of hearsay? How can you bring some hearsay, mister? Where were you 30 years ago? Where were you 30 years ago? Now, where were you 30 years ago, Mrs. Cindy M. Mercer? In college, right? So now you are presiding over on a case where you were not even of age, you were still in college. You know, that's pathetic. And it's on the record. Item 9. No agency has been introduced by Thomas M. Seller, Vincent Serafino, Gary Waddell Reckner, Jen Bain, PC. Fictitious entity cannot be represented by a fictitious agency in a fictitious language in violation of Rule 602 and 601 of the Federal Rules of Evidence. No license to practice in New Mexico, no registration or standing to perform in the Superior Court of Record, no bond requirements of $2.5 million have been met by the Superior Court of Record, no contract between Wells Fargo Bank and the Honorable Adelina Arriaga Pedrosa, no authority to even address the Honorable Adelina Arriaga Pedrosa, one of the people, live human being. Therefore, the fictitious claim of Wells Fargo Bank is hereby dismissed with prejudice. 72 hours from filing of this second writ of error for the Superior Court of Record and the Honorable Adelina, Adelina Arriaga, Pedrosa, period, reserves the right to protect her protective rights as stated on the lawful notification, page 1 of 4, 3 of 4, 4 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 of to all trespasser, wrongdoers, correspondence, rapist names listed on attachment 1, and hereby charges Curtis Espinosa with rape and criminal trespassing, adding Curtis Espinosa to attachment 1, page 144, book page 23 of the book file on demand under Title 28 U.S. Code Section 1361 via U.S. certified mail in the article number 7018-3090-000 2832-4814, and to the attention of Philip Romero, Court of the Clerk at the 13th Judicial District Court of Valencia County. Item 10. Pursuant book page 44, writ of error, demand for dismissal, page 103, also filed on July 12, 2019, legal argument. We had already filed and say, hey, dismiss this because this is not right. No, another writ of error to tell you again to do it. You know, what a shame, what a pity, what a sad story. I mean, you guys are exposing your action to the world. Nobody knew how to do anything in there. Item 11, pursuant book page 57 to 62 were filed by U.S. certified mail with return receipt request 7018-3090-0000-2589-0381. Please refer to page 62 and identify date 8/13/2019, received successfully by Philip Romero, who confirmed felony perjury when he testified under penalty of perjury on the certificate as to the state of record and non-appearance activating Title 15 U.S. Code Section 1692E, false and misleading representations, violation of AUSC 5 due process, and violation of U.S. Code Section 201, U.S. Code Section 2071, concealment herein attached for reference, and mark the People's Exhibit 727. For the Honorable Adelina Arriaga Pedrosa is an active member of the Military Welfare Service. And the National American Red Cross. And when I say the welfare, the Military Welfare Service is throughout the entire world, not just here on the United States or Mexico. And she is an active member of the military. Philip Romero, you went over there under penalty of all, saying no, she hasn't filed anything when you kidnapped the book. And we have the forensic evidence on these documents. Are you going to jail for the rest of your life? You don't do that. It's clear everybody here on this county is well organized, committing this crime, and then, you know, the worst part is that you were told on writing. You know, just this one, U.S. Code Section 2071 carries a 3-year sentence for tampering with the evidence, and we have it right here. We have it right here. Title 18 U.S. Code Section 2071, concealment, removal, or mutilation generally. Whoever willfully and unlawfully conceals, removes, mutilates, obliterates, or destroys, or attempts to do so with intent to do so, takes and carries away any record, proceeding, map, book, paper, document, or other thing, file, or deposit with the clerk or officer of any court of the United States, or in any public office, or with any judicial or public officer, of the United States shall be fined under this title and imprisoned for no more than 3 years or both. B. Whoever having the custody of any such record, proceeding, map, book, document, paper, or any other thing willfully and unlawfully conceals, removes, mutilates, obliterates, falsifies, or destroys the same, shall be fined under the title or imprisoned for no more than 3 years or both, and shall forfeit his office. You can no longer be there. It's obvious that you will be causing great harm. As you have cause for the Honorable Adelina Arriaga Pedrosa. No more than 3 years or both, and shall forfeit his office and be disqualified from holding any office under the United States. As used in this subsection, the term office does not include the office held by any person as retired officer of the Armed Forces of the United States. And it gives you the law right here. Take your screenshot, write it down. Item 12. The Superior Court of Record invites trespassers, wrongdoers, rapists, correspondents' names listed on attachment 1 to each file and serve on all other interested parties an affidavit with the findings of the facts and the conclusion of equitable law. And nobody replied. Nobody challenged. Hey, if somebody sends me something that is accusing me and I challenge, well, I'm defending. Did you defend? No, you didn't. And in this business, if you don't object, you accept it. So you accepted this. You say, okay, well, then I'm a violation. To show cause to the Superior Court of Record why this order to dismiss with prejudice the fictitious complaint of Wells Fargo Bank against the Honorable Adelina Arriaga Pedrosa should not take effect to be modified by the Superior Court of Record, mindful of the rights of the parties and the importance of a fair play, will liberally construe the arguments presented. All documents must comply with the Superior Court of Record language requirements pursuant page 1 of document 14 for the language of the case. Nobody. Let the record show that nobody sent any documents from that point forward in the requested language. For the Honorable J. Period, column, Jesús, hyphen, Arriaga, column, Avonce, period, Federal Postal Judge, witness the court seal on this 27th day of October 2019, and it has the autograph J. Period, column, Jesús, hyphen, Arriaga, column, Avonce. For the Honorable column J. Period, Jesús, hyphen, Arriaga, column, Avonce, certified that one of the copy mail of the listed trespasser certified that for the copy mailed to the listed trespasser wrongdoers rapist correspondent's name on listed on attachment 1 is with the confirmation of a mailing pages. On second read of error via U.S. certified mail. with return receipt requested to Philip Romero, court clerk of the court, to file on demand under Title 28, Section 1361. You're violating Title 18, Section 1361. You didn't file the book. You kidnapped it. You knew it. It was a $50,000 fine. Plus, if you would have known more, you would have known that by doing so, you would have made yourself eligible for fines and penalties in the forfeiture of your office. Now you're gonna have to go to prison to eat potatoes. No burgers there, I can tell you. Potatoes every day. So I can only tell you that. And if they find out inside that you were a judge, I wouldn't want to be on your shoes, honestly. Appointed Special Master in Common Law, Executor and Judicial Officer of the Superior Court of Record, the Honorable J. Period, column, Jesús-Arriaga, column, Avance, period, comma, by an authority of the Honorable, column, Adelina, Arriaga, column, Pedrosa, period, comma, Federal Postal Judge Sui Juris. And then we send you this analysis of the documents you're bringing. Each of these words has a number on top of the word for a reason, because on the analysis of the language, all of these numbers represent a violation. And on the language, on the document for the language of the case, we told you clear that for every mistake you'll be paying $1, and then 2 for the second, 4 for the third, 8 for the fourth, 16 for the fifth, and so on, 32 for the sixth. You know, in this document, there is all the mistakes that you made. Plus, it's got inclusio. Inclusio is like you include one, you exclude all others. You cannot have 2 people on the same complaint. Plus, it's not even verified. This is how sorry you guys are. You're bringing a corporation out here, you know, and then right here on the lower part, now you're writing it on the correct case. Based upon that, document is bogus. 1. It's not even filed under oath. 0, it's invalid. 3, and pay attention. Inclusio is worthless. This guy here, this lawyer of yours, Cindy M. Mercer, Vincent Serafino, Gary Waddell, Genevieve, Papa Charlie. They have no authority. They don't even know how to write. I mean, you know what? They filed this document in violation and contempt of court on the name of a plaintiff that do not exist. In a foreign language, with violation of title. No, this document is written on bastardized grammar. Bastardized grammar. Intentionally. With the intention to extort. In this document, Juan Philip Romero allowed this document to be filed on March 28 of 2019 at 4:49 p.m. But we rejected it. We say, hey, what is this? We already told these people not to do this. We need a language. Now we even enclose this little document of the concealment, the one we just read. Violation of U.S. Code 2071, concealment, removal, or mutilation. Come on, guys. What's going on? What's going on? I mean, I receive a document like this, I will say, if it's going to cost me my job, I won't do it. So you were challenged in every single possible way. And now, by the way, this is the book that was kidnapped. Sad, very sad. And then this one here was presented. And this one here, the objection, we already read it a couple of times, and we already gave you an idea of what was that you were looking at, and you still didn't stop. Although in the very portion of page 404, the very footnote of page 404, under Title 18 U.S. Code Section 1651, piracy under the law of nations, whoever on the high seas commits the crime of piracy as defined by the family of nations, and it is afterward brought into or found in the United States, shall be imprisoned for life. Guantanamo. You're going to go to Guantanamo. Because everything that was pointed to you and ignored, there was solid forensic evidence that you proceeded maliciously. And malicious prosecution is something to be taken rather seriously. You don't do that. You've heard Adrian Polanco. Adrian Polanco told you exactly what it was. He says that if you proceed you will be on clear violation of it, because it is inconstitutional. Okay, so in the meeting scheduled for February 18, 2020 at 11:45 a.m. Cindy M. Mercer was told not to schedule, because if she did, we will be glad to attend or assist or be there, but certain conditions and things must have been taken care of first. Certain things must have been taken care of first, correct? I went over there. Her accomplice never showed up. So we came back to the office and we wrote an affidavit of truth and writ of declaration on the case number Delta-1314-Charlie Victor 2019-00392. And it was filed on the district court on the United States. On the state of New Mexico, County of Valencia, 13th Judicial District Court. Received by Philip Romero on February 20 of 2020. On February 18, 2020, approximately at 11:32, courtroom 201 at the 13th Judicial District Court of Valencia County, the Honorable J. Jesús-Arriaga Ponce, the Honorable column, J. period, column, Jesus, period, hyphen, Arriaga, column, Abonce, appointed special master in common law by the Honorable column, Adelina, hyphen, Arriaga, column, Pedrosa, Federal Postal Judge, who are jurors and one of the people, The Honorable J. Jesús-Arriaga Abonce assisted on the hearing on behalf of the incapacitated by health reasons, the Honorable Adelina Arriaga Pedrosa, and verbally asked, is this the 11:45 a.m. hearing? Cindy Mercer, judge, answer. No. The Honorable J. Jesús-Arriaga Abonce sat on a bench outside the bar area and asked again, is this the courtroom 201? Bailiff, Secretary, and Cindy N. Mercer replied yes, simultaneously. The bailiff provided registration booklet wherefore the Honorable J. Jesús-Arriaga Abonce subscribed by given name. At exactly 11:45, for the Honorable J. Jesús-Arriaga Abonce stood up from the bench and stated verbally out loud, Your Honor, please take judicial notice of the time and the absence of opposing counsel. The bailiff attempted to quiet the Honorable J. Jesús-Arriaga Abonce and said, Sir, you are on our time. You'll have to wait. At 11:49 and 53 seconds, the Honorable J. Jesús-Arriaga Abonce stood up for the second judicial notice to Cindy M. Mercer and verbally expressed out loud, Your Honor, please take judicial notice that the time now is 11:49 and 53 seconds, and please take judicial notice that the fact that the opposing counsel has failed to appear, and I'm here to deliver these documents. Notice, mandatory judicial notice, read of quo warranto with proof of claim and a laudable fee scheduled private. 4 pages of the People's Exhibit FUC, Foxtrot Uniform Charlie, 3 pages forensic evidence of contempt ruling and unlawful practice of law by Cindy M. Mercer mail fraud in violation of Title 18 U.S. Code Section 1342, document number 2, delivered and filed by the Honorable J. Jesús-Arriaga Abonce on February 18, 2020, 10:16 a.m., Administrative Remedy Claim 1, column 20, Charlie Victor dash 00113 dash Juliet Hotel Romeo, filed at the United States District Court on February, filed on the United States District Court for the District of New Mexico on February 7, 2020, against all correspondents listed on documents 17, 18, 19, and 20. Document size, 65 pages. That's the criminal complaint. And we have 65 pages to read. The Honorable J. Jesús-Arriaga Abonce extracted the documents from the yellow manila envelope and placed them on the left side desk of the bailiff, verbally stated, Sir, we are not going to receive these documents. The Honorable J. Jesús-Arriaga Abonce placed the third judicial notice. Your Honor, please take judicial notice of the time 11:49 and 53 seconds and the absence of the opposing counsel, and the Honorable J. Jesús-Arriaga Abonce left the courtroom number 201. Counsel for the fictitious plaintiff failed to show, abandoning all claims against the fictitious entity Adelina Arriaga. This document has an autograph. And is also notarized as a notarized witness knowledge. J. Period, column, Jesús, hyphen, Arriaga, column, Abonce, period. The Honorable, column, J. Period, hyphen, column, Jesús, hyphen, Arriaga, column, Abonce, UCC 1-308, 103.6 and 109. And we all talk about those numbers. Does that sound familiar by now to you? Appointed Special Master in Common Law and Judicial Officer of this Superior Court of Record by an authority of the Honorable Adelina Arriaga Pedrosa is one of the people, Federal Postal Judge, sui juris presiding this Superior Court of Record. Notary Witness Knowledge, State of New Mexico, County of Valencia, Notary Michelle Vasquez, commission expires in 11/10/20. Personally known to me, proved to me on the basis of satisfactory evidence. Top B, the people whose names is subscribed in this instrument and acknowledge that he executed it. Read of declaration. So if somebody goes over there and declares something under oath and the opposing counsel do not challenge, what does that mean? One of the maxims of law is that whoever leaves the battlefield loses, and he didn't show up. Well, he didn't show up for a reason. For the Honorable Adelina Arriaga Pedrosa instructed to call him over the phone and warn him that if he came over or continue on that path, we shall use this evidence to bring him into federal prison. The guy didn't show up. Didn't show up. But it doesn't mean that he is out of the hook. He just didn't show up. But all of these things that we have pointed to this to the Congress Oversight Committee are clear evidence. Clear evidence, and then and we have one more document here that we're going to be introducing you to. Cindy Mercer, Vincent Serafino, Wells Fargo Bank. You received this document by fax. This document was faxed. For the Honorable Adelina Arriaga Pedrosa, fax this document to you to Judge Cindy M. Mercer, fax number 505-866-6813 from Adelina Arriaga Pedrosa, case number Delta 1314 Charlie Victor 2019-00392, 4 pages including cover, on this December 3rd of the year 2020. December 3rd. Because supposedly you had scheduled a hearing for December 9th, I believe, of the year 2020, and the time we'll get to it. And it read from to column Thomas M. period Sellers, fax 214-979-7402 from column Adelina hyphen Arriaga column Pedrosa period. Case number Delta 1314 Charlie Victor 2019-00392, 5 pages including cover, and this is on December 3rd of the year 2020. Successful transmittal on the top part of this document. Very successful transmittal. Time, date. To Judge Cindy M. Mercer, fax number 505-866-6813 from column Adelina hyphen Arriaga, column Pedrosa, case number 1314, Charlie, Victor, dash 2019-03392. 4 pages, including cover on this December 3 of the year 2020. Many of you will probably don't have this document because this is a recent fax that was sent in regard to all these 5 cases, so we're gonna read it, but you can take your screenshot. For the Honorable Adelina Arriaga Pedrosa wrote to Judge Cindy M. Mercer and Carl W. Raystick, General Counsel, fax 505-866-6813. Case number Delta 1314 dash Charlie lowercase Victor lowercase dash 2019-00392. It is the wish of this Superior Court of Record that all matters be released from the 13th Judicial District Court, Valencia County, to the Supreme Court of the United States for the judicial review, to the attention of the Honorable John G. Roberts, Jr., Chief Justice, and Carl W. Raystick, to forward all documentation contained on the record of the following cases. Case number Michael, capital letter Michael 059 Michael dash 059 dash Charlie uppercase Victor uppercase dash 2017 dash 00524 Magistrate Court, Valencia County, Los Lunas. Case number Delta 1314 Charlie Bravo 201-800-590 13th Judicial District Court, Valencia County. Case number 1314 Charlie Bravo 2019-01-401 13th Judicial Court, Valencia County. Case number Michael 60 Michael Romeo dash 2019-00267 Magistrate Court, Valencia County of Belen. Case number 1314 Charlie Bravo 201-900-392 13th Judicial District Court, Valencia County, and case number Michael 59 Charlie Bravo 20-00059 Magistrate Court, Valencia County, Los Lunas. Warning to all counter defendants listed on the attachment 1 and all the above cases, and also listed on the criminal complaint, case number 1 column 20 dash Charlie Bravo lowercase dash 0013 dash Kilo Golf uppercase Juliet Hotel Romeo uppercase. You are hereby compelled to subscribe to the YouTube channel for the Honorable column J period hyphen column Jesús hyphen Arriaga column Avonce for the criminal video trial for the criminal video trial in the Corporate United States District Court for the Corporate District of New Mexico, and in the Supreme Court of the Corporate United States, and in the International Court at the Peace Palace in Hague, Netherlands, who has a permanent seat on front of the Permanent Court of Justice on front of the United Nations. Failure to subscribe within 72 hours of this notice will render all trespassers free, fugitive, and subject to arrest by the United States Marshal's Office and Interpol. You have been served. Must register on the comment section and watch each video presented on the aforementioned channel. It is ordered on this 3rd day of December of 2020. These items were returned. Unopened. And on the back part of it, they were refused per cause, Uniform Commercial Code 1-308, 1-103.6, and 109. Without prejudice, all rights reserved, not the real parties at interest, wrong name, wrong address, and is being filed for this federal post court. Filing by this federal postal register number. Romeo, capital letter, Echo, capital letter, 119-486-83 US. That is the maritime contract that you enter. It was filed on the Superior Court of Record at the time of 9 o'clock and 58 minutes on the AM, and it is autographed by the Honorable Column Adelina Arriaga, Column Pedrosa, Clerk of the Court, who also reserves her rights under the UCC 1-308, 103.6, and 109. The time now, (18 minutes past 6 in the afternoon). This is Friday, December the 18th of the year 2020. We will continue in another case. The next case that we are going to move forward with is the case regarding the foreclosure, the bogus foreclosure, where there is no record of the transaction ever made. So it's going to be quite interesting. Bring your notebooks, rewind this video, watch it more than once, comprehend it. Keep in mind that all of these documents that have been read are supported by existing law, and they are forensic evidence. Also consider the video from Clarence Thomas, part of this video, as forensic evidence that you must comply with the language or else you have nothing. Absolutely nothing. And in the federal court, the judge says that if you didn't have the real names, well, then you didn't have anything either. So now you have to go and battle with them. Plus, we already proved our point. We already made our presentation on paper, on a written process, under Title 28, Section 636, lowercase Gulf. And under this delegation of powers or jurisdictional powers. In this video, we are giving a temporary assignment to the Interpol and the United States Marshal's Office to take immediate action and arrest these trespassers. You're gonna be hearing, you're gonna be watching this video, and based upon, not based upon what you see, because you are not a lawyer, you are not a judge, you are not even here sitting down to judge anything. The proceedings are over. They were given the opportunity to comply. It is clear that they are on all this violation, and if you shall fail to comply under your oath and contract, and then you will compound yourself, whoever you are, to the same constitutional wrong, and it is on the record now. For the chief of police on Interpol, for the U.S. Marshal and for the United States Marshal, General Virin, you need to comply with your oath. For the Honorable Adelina Arriaga Pedrosa accepts your oath, reminds you of your fiduciary duty, extends her sovereign immunity while you carry her order of arresting these trespassers. And if you don't do it, well, then will be clear forensic evidence of collusion, and you will be self-volunteering or compounding into this constitutional wrong. We are now in front of this the corporate United States Congress Oversight Committee. We are in front of 9 judges at the Supreme Court for the United States, and we are also in front of the 9 judges, or of the panel of judges at the International Court at The Hague, who has a permanent seat in the permanent Court of Justice. And we are filing this also at the UNESCO. Uniform, November, Echo, Sierra, Charlie, Oscar, UNESCO. And we are placing a petition in the tribunal at the Institute of Derecho Procesal del País Vasco in San Sebastián, España, to take a look of these proceedings, to where we have invited for the Honorable Juan Burgos, Ladrón de Guevara. Also, for an analysis of this proceedings, it has been an honor to make this presentation and this analysis of law for the Honorable Column Adelina Arriaga, Column Pedrosa. Who reserve her rights under the Uniform Commercial Code 1, dash 308, comma 1 dash 103.6, comma, and 1 dash 109. Again, thank you very much for your time. This court will always remain open. This court is not adjourned until we get everything resolved and the amount continue to accrue at the tune of $50,000 per day in lawful money minted by the United States Treasury until all matters are resolved in the courts we just mentioned. Again, thank you for your attention, and we're signing out. We shall be continuing, and the first chance we get, and we're going to bring you some quite interesting evidence in regard to a mortgage that do not exist. Thank you very much.